Well, good morning to everyone, and thank you all for joining the World Federalist Movement Institute for Global Policy and the Institute for African Women in Law, who are co-sponsoring today, and our esteemed panelists for this event, where we'll be unpacking the contributions, gains, and challenges for women in international justice. I'm Jessica Boulet, Human Rights and Gender Specialist at WFM-IGP, and I have the pleasure of moderating today's conversation. Nearly 2 years ago, the UN Human Rights Council adopted a resolution that women remain underrepresented in several UN bodies and mechanisms responsible for developing international human rights norms and standards. This month, the 65th Commission on the Status of Women adopted agreed conclusions highlighting the need for equal representation of women and men in executive, legislative, and judicial bodies. Unfortunately, in a number of international legal bodies, women in decision-making positions don't even constitute the UN-endorsed critical mass of 30%, which is deemed necessary to effect institutional or cultural change. This means we are far from achieving not only gender parity, but also the associated benefits, which include the greater representative legitimacy of judicial institutions, improved justice outcomes, and increased opportunities for women. Looking at the regional level, at present, 19% of the members of the European Court of Justice are women. 14% of the members of the InterAmerican Court are women, and 20% of sitting judges on the East African Court of Justice are women. At the UN level, the 9 human rights treaty bodies boast nearly equal representation of women and men on average. However, this seeming parity is only made possible because the CEDAW Committee for the Elimination of Discrimination Against Women is 97% women. Only 3 other treaty bodies have achieved gender parity. Meanwhile, out of 34 members of the International Law Commission, only 4, a mere 11%, are women. At the same time, we are now able to contrast these disappointing numbers with other international bodies that are more representative, such as the Inter-American Commission for Human Rights, where 71% of current members are women, or the African Court on Human and People's Rights, where 6 of the 11 current judges are women. Our esteemed panelists today all have deep experience contributing to international law and justice in various fields and capacities, including in relation to many of these bodies. Today, they will reflect on the achievements, obstacles, and benefits of women in international justice, as well as issues specific to the UN and their regional areas of expertise. And certainly, collectively, they bring quite a lot of expertise. So if I may start with the introductions. Dr. Jarpa Dawuni is the founder and executive director of the nonprofit Institute for African Women in Law, our co-sponsor, which works to enhance the capacity of women in the legal professions in Africa and the diaspora. Dr. Dawuni is also Associate Professor of Political Science at Howard University in Washington, D.C., where she also serves as Director of the Center for Women, Gender, and Global Leadership. Her primary areas of research include judicial politics, women in the legal professions, gender and the law, and democratization and women's civil society organizing. And she recently co-edited 2 books on women, gender, and the African judiciary. Dr. Juliane Cocotte has served as Advocate General at the Court of Justice of the European Union since 2003, in which capacity she has been responsible for approximately 1,300 cases and has delivered around 600 opinions. Prior to joining the court, Advocate General Cocotte was a professor at the universities of Augsburg, Heidelberg, Dusseldorf, and St. Gallen, as well as a deputy judge for the federal government at the Court of Conciliation and Arbitration for the OSCE, and a deputy chairperson of the Federal Government's Advisory Council on Global Change. She has authored and co-authored a broad variety of publications on European law and public international law, as well as on EU economic tax and competition law. And last but certainly not least, Commissioner Margaret May Macaulay is the current president of the Inter-American Commission on Human Rights, on which she has served as a commissioner since January 2016. President Macaulay also serves as rapporteur on the rights of persons of African descent and against racial discrimination. She is mediator, associate arbitrator, and notary public in the Supreme Court of Jamaica, and she previously served as a judge of the Inter-American Court of Human Rights from 2007 to 2012, where she contributed to formulating the court's rules of procedure. She took part in the reform and drafting of laws in Jamaica and is well known as a strong proponent of and authority on women's rights. So please join me in welcoming these distinguished leaders in the field. So now for today's panel, I would like to open the discussion by getting a lay of the land. Where are we now, including current challenges, and what can we learn about the evolution of international justice mechanisms as women have increasingly achieved greater involvement in these spaces? I would like to pose the first question to all three of you, with about 5 minutes for each of your responses. And we'll also leave ample time at the end for the Q&A for the audience. So as questions arise, please feel free to drop a question in the chat, and we will make time for that later on. So without further ado, for our first question, what gains have women made towards gender balance in judicial mechanisms on the international and the regional levels? And in your views, what has that process looked like? And perhaps for this one, we can start with Professor Daouni, moving on to Advocate General Kokot, and then Commissioner Macaulay.
Thank you very much, Jessica, for that wonderful introduction. And thank you to WFM-IGP for having me here. I'm really honored to be amidst great colleagues like Dr. Kokot and Commissioner Macaulay. I would like to limit my response more to the African context so that, I think the panel has a great diversity in terms of regional focus. So that gives us room to kind of focus on our regional specializations. But I'll start off with the United Nations. As we know, the leading organ in the world for issues of global politics, human rights, and other issues. And one of the main organs of the UN is the International Court of Justice. As we know, it's been in existence since 1946. But if we look at the current composition of the ICJ, the International Court of Justice, we still have a low representation of women in the historic existence of the court, over 108 judges, and we've had only 4 women. And so if we depart from the UN, there's still a lot of work to be done. However, other courts, regional courts that have been established since the UN ICJ, have tried to learn somehow from the experience of the ICJ. So for example, the ICC, the International Criminal Court, has learned from many other participants in the creation of that court, the Rome Statute, which established that court. Many advocacy efforts by women's civil society organizations like the National Criminal Court Coalition to make sure that they have gender representation or gender parity on the bench of the courts. So if you look at these 2 international courts, one, which has been the longest surviving court, the ICJ, still has a terrible record in terms of its composition, which goes back to the statute creating the court, which would have to be amended for that process to probably change. But there are still other ways in which the gender parity can be increased even without the amendment of the court. The ICC has done a good job in terms of being the most current recent history to be established court to try to amend those problems. So if we take these 2 courts, one is doing good, one is doing terrible. Now, if we come down to the regional court, and I want to focus on the African context, the main regional court within the African context is the African Court on Human and People's Rights, which you mentioned. This court came into existence just about the time that the ICC also came into existence. And so it goes back to the law establishing the court and how they also made provision for women or gender parity to be achieved or women's representation. And apart from that, it's also that efforts were made outside of the protocol established in the court to ensure that there will be representative voices in terms of gender. So as you said, the court currently is the most gender balanced court in the world, we would say, at 6 women judges to 5. And within the context, there's still a lot of discussion to be had, which I'll not discuss now. But very quickly, moving on to sub-regional courts and tribunals like the ECOWAS Court of Justice, which is for countries within the ECOWAS region, it has also done some remarkable work in terms of the historic representation of women, about 30%, still a lot to be done, but currently it has 2 out of 5 judges sitting, 2 of them being women. And then lastly, talking about the SADC court, which is for, sorry, not the SADC, COMESA, which is for the commercial region of South Africa, it's also doing well in terms of women's representation. So all of this to say that progress has been made in some spaces, learning has happened, institutional learning has happened, but if we want to talk about the main body, the ICJ, there's still a lot to be done.
Thank you so much, Professor Daoni. And now I think over to you, Advocate General.
Yes, I will be short because there is no real progress. We are 7 women out of 38 members. That means about 19%, 6 out of 27 judges, 1 out of 11 advocates general. And that's the tradition of the court. It was founded as an all-male institution. In the 50s, 6 judges, male judges, 2 male advocates generals. Then there was a period from the 80s to 2003. There were from time to time 1 female member from time to time, but mostly not. And things changed a little around the time when I arrived at the court, that is in 2003. From then on, there were some female judges and advocates general, but not enough, like 1/5, little less than 20%. So it's no success story until now. But I think we come to the reasons later. Thank you.
Thank you. Short and sweet, yes. And now over to you, Commissioner McCauley.
I will stick to the region of the Americas, and we have a mixed record. It's the court, the InterAmerican Court, had been a male court for many years. And then in 2006, they had 1 woman. And that went on until, that is Judge Sonia. And that went on until she was joined by Donna Cecilia Medina. And then Sonia left the court, finished her period of service. And Cecilia was the only one. And then in 2006, this was early, 2002, I think it was, that Sonia was there. Then I joined the court, and in 2006, I was elected. And I was elected with another woman judge, Radis Polanco from Dominican Republic, and we joined Cecilia. So for the first time in its history, there were 3 judges. And for the next 6 years, we made our presence felt in gender justice in all the cases that came before us. We had to do that. I should add that I'm also the rapporteur of women's rights at the Commission. And when that term ended, and I did not return to the court, and Radis did not return to the court, only Cecilia, and Cecilia had left before. She couldn't go back in any event. So there were no women judges for the next 6 years. And until the current president of the court, Elizabeth, was elected, nominated by Costa Rica. And she is presently serving. She is not going to be returning after the next the end of this year, from the end of this year. And so we actually had a session on the situation, which is sort of, we thought, a crisis situation on that issue. And we wrote a letter to the General Assembly of the Organization of American States about it. Because largely speaking, it's in the hands of the states. They choose who they nominate, and those are the people who are up for election. And so therefore, we're working on the states to nominate more women for the position of judge in the court. In relation to the commission, with the aid of civil society, we succeeded in now having 5 women out of 7. And for the first time in its history, the board is made up of 3 members. We have 3 women making up the board. And by the way, I'm no longer president. We change each year. So we now have, just recently, this month, we have Antonia Orojola from Chile, and we have Julissa Mantilla from Peru, and Flavia Provisan from Brazil, who make up the board in the thing. So for the first time ever. Whether this will continue is a huge question, because as I say, it remains with whom the states nominate. And we all know that there are problems still about gender parity in all the states who do not feel committed to that standard and requirement for going forward. So in 2015, I attended an international conference in The Hague, which was pushed and set up by CEHIL, the largest, very powerful civil society in the region. And they had been doing research on the various courts, and were so appalled by it that we had this international conference on GQual, and where we had all the data about all the courts in the world. And as Professor Dewani has said, the ICJ had the worst record apart from the InterAmerican Court. But that is a very small court compared to the ICJ. And it's a very young court compared to the ICJ. And I think we will succeed in overcoming the difficulties, because we are working on the states. And I know that after our presentation of the letter to the Permanent Council, one of the states who nominated a candidate changed their nomination from a male to a woman. So we're getting there. Thank you.
Can I make 2 short comments? I was working as a student for Tom Bergenthal, who was then president and judge at the Inter-American Court. And at that time, it was an all-male court, but Tom Bergenthal always said, it's so bad. I would so much like to have at least one woman. Even one woman changes the whole atmosphere and the whole culture of discussion. That's the one comment. And the other, and the name of Sonja still rings in my ears, because he mentioned she could become, maybe she can, maybe she will succeed, and he was so much hoping for it. That's one thing, but not all men are like that. And then I think the African and Latin American women can serve as role models for us Western Europeans, because you do fight and you have success. And I think we are not active enough. Thank you.
Thank you all. Yes, an excellent beginning to set the scene and to sort of dig a little bit deeper in that. Can I hear a little bit more? Can we all hear a little bit more about the challenges remaining for these bodies? And in particular, has there been any impact of the COVID-19 pandemic on how these international justice bodies are evolving and how women have been able to participate? Of course, especially as judges, as advocates, but perhaps also as victims or witnesses. And maybe for this one, we can go in the opposite order and start with Commissioner Macaulay.
Am I on? Yes, thank you. Challenges remain, definitely, because the Americas, we have a very strong and active machismo the society in so many of the countries, still solid, and sometimes, and if you look at the regressions we're having, the pushbacks in relation to women's rights, it is quite obvious that it is being pushed even stronger, because we're having to really take very strong stands and very critical approaches to the machismo culture, and which of course impacts on who they choose to be in decision-making positions or high-level positions of service. And we have a serious problem in relation to job segregation in the region because of this, and the lack of political will in so many of the states to change the status quo of machismo and the old boys network. But as I say, we do make inroads, and sometimes it is strange to say, but sometimes it is a chance of time that if you have the candidates at a particular time, they have no other choice, because they're small. It's a small court. It's a small commission. Both are seven commissioners, 7 judges. So at a particular time, the choice is not so great that you have to vote for certain people. And if they happen to be, as happened in the 2 recent elections, women outnumbered the good candidates. And this is why I hold the position of rapporteur on women's rights. That the old argument about, oh, well, we have to educate more women and so on and so forth, I think is rubbish. Because we have so many outstanding women that doesn't hold anymore. It is the lack of social will and the lack of political will of the men who are still in positions of power in their domestic power structure, that we're still having these challenges. And that's, so I say that one of the things that we have to do, and I speak to lots of women's groups about this, is that we have to move for far more involvement in the political arena of the domestic countries, because one feeds in the other. So we have to have more women in positions of power. And I have to say this, that Caribbean countries are doing better in that regard than our Latin American countries, because we have had more women who have headed the executives in our country and still do, and than there are in Latin American countries. We've also had more women chief justices of the Supreme Courts of Caribbean countries than, well, there's been none in Latin American countries, not one. And of course, it seems to me, for instance, in Jamaica, that the last count I did about judges in Jamaica, women far outnumbered men in the Supreme Court. And they are at, I think they also outnumber men in the Court of Appeal. Whereas that doesn't happen in Latin American countries. So therefore, we are trying to work assiduously to break the machismo syndrome in these countries. Because if we don't, it will continue in that vein in Latin American countries, which is a serious challenge that remains. As far as COVID is concerned, we have been working, and without women's input, I don't think our structures would produce half of what has been produced in the last year. And in fact, it was said in one of our meetings that we have produced, in some instances, 4 times more than before COVID annually. And let's face it, because we are in lockdown, most of us still, serious lockdown, and we are sort of lambs to the slaughter for every piece of every kind of meeting there that can be conceived, every kind of drawing up of resolutions and so on. And we voted on more cases and petitions than ever before. So therefore, women have been participating a great deal more than they would have before. And since there are 5 women in the commission and 2 men, honey, we are certainly putting out the elephant share of the work in the commission. In relation to the court, I am Poor Elizabeth Audio is the only woman, and she's the president. So during this COVID year, which has been gone by and which she's going to finish at the end of this year, she has had to carry a very, very heavy load. And it is a heavy load to begin with when she, the sole woman, is the president, and the other, her colleagues are 6 men. But they have continued the work which Cecilia, myself, and Radis did when there were 3 women in the court in relation to gender justice. And so that is good so far. And as I say, luckily, we haven't had any of the members fall as victims to the infection and the infection with COVID and suffer permanent injury. So far, I would say that it has had more of a positive impact work-wise and less and a negative impact on each of us personally for our mental health, our eyes, our bodies, and the number of hours we spend in front of a screen, which we never used to do before. We're more in the commission, we're more a person, and even in the court, we're more personal contact. So, which we miss quite a bit. And when at the end of a day, we just finished our 2 periods of sessions. At the end of the day, you're a zombie. And I certainly do not want to look at a screen, TV or otherwise, at the end of a day. So there are adverse effects on us, which we will hopefully recover from very shortly, perhaps this year, if we're lucky, if humanity is lucky. And the COVID virus releases us. So I think with that, I think I've covered every point. But women generally have been adversely affected by COVID, much more than men in the region. And poverty is increasing for women. And of course, our responsibility became even more so. And then there's the increase in violence within the home, domestic violence. And it's created serious problems for women generally. But for members of the judiciary or judicial bodies, not so much, except the usual. Thank you.
Thank you. Yes, and for Advocate General Kokot?
I agree with Commissioner Macaulay that for sitting judges, it doesn't have a negative effect. We just work even more. Yeah, we are more productive. But I think it has an indirect effect for the people, for the women to come, because at least in Germany or here in the European region, probably worldwide, women just do the household, and combining work and motherhood is anyway very difficult in Western Europe. There are no functioning family structures, and you just cannot afford domestic care, and there are all kinds of disincentives. And so you sit here and you do not even have kindergarten, and you have to work at the same time and cook and take care of the children. And under such conditions, it's even more difficult than usual when you have at least kindergarten and school to become eligible for high positions. And of course, all this is always considered private choice of the parents. That's always the idea, the old distinction between private and public, and the state just doesn't have to interfere. But that's a very short-sighted and I would say one-sided view. Yeah, it's not so really a very free choice. It's just the usual following of stereotypes and role models, and it's to the disadvantage of women. Of course, there are also counter examples of extremely nice and helpful men, but the majority of the women are affected by this more than men. Thank you.
Yes, the classic division persists. The idea that this is personal choice, certainly. And Professor Dawouni, over to you.
Yeah. Thank you. I mean, my two colleagues have said it all, really. I'll just be repeating what they've said. And I think I'll add two quick points. One is that we also have to be mindful and remember all the time that there are differences among women, and there are differences among each individual's experience, from one experience to the other. So in as much as we are looking at these from general patterns about the issue of the double work that women have to do, the private and public now blaring as they've always have, we also have to think about the differences in resources. I've had interviews with judges and lawyers and of course webinars, and in some countries, and I'm speaking once again, being careful not to speak like Africa is a country, but across the continent, very vast continent of Africa, I've engaged with different people in different spaces during this COVID-19 virtually. And some people do have a problem with internet connectivity, not because they don't have the money to pay, but if you're located in a region of the world where we don't have the fiber optics to give you the best broadband, it becomes a problem for how effectively they can work. And it's not just about their home location. I mean, here in the US, I tell my students I've paid for the highest Wi-Fi that my company can give me, but there are times when I'm teaching and there are glitches. So it's about resources, and not just just the internet connectivity. I know that in most African countries, they have power issues. Electricity can go out. So that could be a problem that would affect the work you do. And apart from that, it's also that even though people often think that women in the continent of Africa or professionals have house help, so they can kind of take care of, someone can take care of the private life for them, it's not always the case. Because you have to do a lot of management of these people who are helping you and who are getting paid, so draining your money, of course. But in the COVID era, most people have also had to close their homes. So even where they may have had help, now they've had to let some of the help go because of the issue of limiting the exposure to infection rates. And lastly, it's also for us to be, to take into account that women, whether as judges or lawyers who work in these spaces, also have, within the African context, once again, dealing with a larger family context than just the family, the man and the children and the dog. We are talking about dealing with families that come in all the time with their long list of needs, and people who are not even related to you coming in and you have to help. So all of these really, once again, just speaking within the African context, and I'm sure this can be largely applicable maybe to the Caribbean region, Latin America region, countries that kind of mimic the cultural heritage of Africa. Most all of these issues are not often talked about, but despite all these problems, I have seen that the women are rising to the occasion like they've always done and doing the best that they can. Because as my colleagues have said, when you are a woman in a position of leadership, and especially if you are a woman of color, the extra burden and layers of productivity and leadership you have to show places an undue burden on these women. And that is something that has the effect on the physical health, but also the mental health. So these are things that we need to consider about the ways in which COVID-19 might be affecting the productivity of women within these bodies.
Yes, and thank you, Professor Dawouni, for highlighting that just the range of experiences that women can have as well. And that's something I'd like to delve in a bit more as also. Oh, yes, sorry about that. Go ahead. Yeah.
Because Japa brought up so many points that are so true. But I wanted to add this. Whilst I was in the court and whilst in the commission, I've always been the only English-speaking member. And I am Black, the only Black as well. And that places an additional burden on me to show that not only can we do the work, but we can do it at the best level ever. And it is almost like you are being tested every day. And that is an educational burden. And I forgot the domestic part. The one takes it for granted that everybody knows it, but that's not true. That's not true. Because I had live-in help, but during COVID, I could not continue with that. And because she herself decided that she preferred to be with her family. And so I had to learn to be cooking my dinner and food every day. It's not fun. I hate it.
Thank you. Yes, and certainly I think again, just with looking at who's on these bodies, and it's not just gender parity, but it's also diversity among the women sitting on these bodies, which has an impact. And so thinking about that, I would like to hear from all of you how the inclusion of women and that the diversity or lack thereof among those women in international and regional judicial mechanisms has influenced gender equitable jurisprudence or the nature of jurisprudence overall. And perhaps this time we can start with Advocate General Cocotte.
I think the European Court of Justice is very special and exceptional in this regard because it produced gender equitable jurisprudence even without women. And I think there are two reasons for it. The first reason is equally extraordinary, and that is gender equitable European legislation, starting with the founding treaties. And the second reason is that a basic feature of European Union law is precisely the abolition of all kinds of discrimination, including in particular indirect or factual discriminations of workers of other member states in the first place. But this concept of eliminating all kinds of even factual and indirect discrimination and of understanding discrimination very broadly was simply transferred to the issue of women discrimination. On gender equitable legislation, it's interesting that the founding treaty explicitly laid down the principle of equal pay for equal work in the 50s. And the reason for this is interesting. It is France's birth-friendly population policy. And wisely enough, as opposed to Germany, France said, if we want to have many children, we must make being a mother and being a working mother easy. And they were very nice to working mothers. And France did not want this to be a competition disadvantage. And therefore it's in the treaty. And it was interpreted very widely as not only applying against the state, but also between private parties. And then all this abolition of indirect discriminations of part-time workers and so forth. And there are lots of regulations and directives of the European Union which lay down that the principle of equal treatment for women and men must be implemented, and for the safety and health of working and pregnant workers, and for maternity leave, and for paid maternity leave, and so forth. And against this background, the court also was very progressive. For example, what we have now pending at this moment before the Court of Justice is discrimination against two mothers, one child, not from one father and one mother, but from two mothers. And the case is a British and a Bulgarian woman married in Spain and had themselves registered, which is possible in Spain, as mothers, both as mothers of a child in Spain. And then the Bulgarian English female couple traveled to Bulgaria and wanted to register their child as a child of two mothers. But that's Bulgaria said that's not our conception of the family. And it's an interesting case. The court, with its very broad idea or concept of discrimination, may come to the conclusion that this is discrimination, but the Bulgarian states, well, it's against our national identity. We have other ideas. Well, to sum up, there is gender equitable jurisprudence by a very male, unduly male Court of Justice. But outside this one example, I'm totally convinced that women do make a difference, that gender balance at the court is absolutely necessary in order for courts to see the full picture and to see all sides and facets of conflicts in the society. And also diversity in a court is important to see the full picture. In my land here, we have a system that just takes the persons who have the best law degrees. And these might be young people of 27 years, and then they are judges. I do not think that this is good. I think that you have to have more qualities as just doing good grades in a very specific law exam. So diversity is very important, and gender balance is also important. I have read many German judgments full of stereotypes about women, which would certainly not have been handed down that way if there had been women on the bench. A very early example of this is an example of the United States Supreme Court, who talked about the natural and proper timidity and delicacy which belongs to the female sex evidently unfits it for many of the occupations of civil life, including that of becoming an attorney, very old and very stereotyped. I also doubt whether women judges would understand the German Federal Constitutional Court's reasoning, end of the 70s. The court reasoned that in granting a tax reduction for domestic health expenses, mothers who take care of their own children's education might feel disadvantaged. I think that's complete nonsense and discriminates against the domestic helps and against mothers for whom it becomes far too expensive to have any help. Yeah. Interestingly, a few years later, the same chamber of the Federal Constitutional Court, which meanwhile comprised only one woman, decided that the rule according to which, in case of future spouses didn't agree on their married name, the name of the husband automatically prevailed, that was German legislation, was contrary to the constitutional principle of gender equality. This might be due to the female component because it's different than the earlier judgment. So, but not only the outcome of the decision and seeing the full picture necessitates a woman on the bench. In a recent judgment of the European Court of Human Rights concerning quotas for women candidates in elections, the European Court of Human Rights not only noted that the promotion of gender equality is one of the main objectives of the society today, the European Court of Human Rights moreover considered that a pronounced imbalance between men and women in politics could jeopardize the very legitimacy of democracy. And I think the same is true for judicial entities, such as highest courts. We do not just mathematically apply the law. We have also some leeway, and therefore, for at least for constitutional and highest courts, there needs to be some legitimacy, which is only there if there is a balance between the genders. Thank you.
Yes, thank you very much for that. And also, I really appreciate the point I think perhaps you were touching on with the way that economic activity is characterized is very important when you're looking at, domestic work and taxation issues, even though that field is often stereotyped as having nothing to do with gender dynamics. So perhaps next we can move to Professor Dawouni.
Yeah, so I want to come at this from a different perspective. One is the question we're even asking: how has the inclusion of women led to some change in these courts and the jurisprudence? It's a great question to ask because we always want to be assessing where we're going, where we are, and what the outcomes really are. And I think there are many outcomes that we can assess than just the jurisprudence of these courts or mechanisms, which I strongly believe are the case. But there are other ways in which we can assess these institutional outcomes. And looking at jurisprudence, there are three things that I may want to point out. One is that judges cannot do the magic, right? Women judges cannot do the magic. If the laws do not exist for them to apply, it becomes problematic, right? So they can have all forms of framing and be creative, but if the laws do not exist that give those rights, then it cannot happen. So based on what Professor Kokot has said, the European Union has these gender sensitive or responsive laws. So it's somehow easy for the judges to apply, and male judges have done so. So that's one thing to think about. The other one is to also look at the supply side of it, if you might want to call it that. Are the lawyers bringing the cases to the courts that affect women? Are civil society organizations pushing and advocating, human rights civil society organizations pushing for these cases to be brought? Now, within the African context, once again, for example, the African Court on Human and People's Rights is based in Arusha, in East Africa. So if member states are located outside of that region, it becomes a problem even to access the courts. Another one is that if countries have not accepted the jurisdiction of the court, the cases cannot be brought to the court, with the exception of a few who might say that, well, non-governmental organizations can also bring cases. And even that, we've seen some countries have withdrawn out of the jurisdiction of the court. So we also have to look at those organizations. Within the ECOWAS court, which is based on the West Africa, and two important pronouncements have come out promoting women's rights in terms of property and inheritance. But if you look at the decision of the cases, it wasn't so much the gender question that they looked at. They looked at it more from the human rights perspective. So indirectly, yes, the jurisprudence promoted women's rights when it comes to property and inheritance of a spouse after the husband has died, but it wasn't so much from a feminist perspective or a woman question. So that is one thing that we might also want to look at, the indirect and direct contributions. Lastly, I also want to point out that when we are talking about jurisprudence, we should be careful not to place the undue burden on women judges once again. And I want to quote very quickly one thing that Judge Julia Sebutinde said. Judge Julia Sebutinde is a judge of the International Court of Justice, one of the 3 current judges. And she's the first woman from the continent of Africa to sit on the court. And she said something very instructive in this book that we co-authored with her. In a world where 1/2 of the population is female and the other half male, I would like for people to say one day that the world court is composed of 50% men and 50% women. That would be gender parity. It serves no purpose for people to ask, what difference or contribution have those 3 women judges made since they joined the courts? For over 70 years, they have been predominantly male judges serving on the International Court of Justice. Yet nobody ever asks those kinds of questions when it comes to men. Why should the female judges serving on the courts have to justify or validate their presence or role on the court? As long as we meet the statutory qualifications and are duly elected, we have as much right to sit on that bench and to participate in the settlement of state disputes without having to validate or justify our presence there with valid addition, period. Okay, so that really summarizes it all. So I want to come from that perspective of women are qualified, they have a right to be here, and they don't have to be asked why and what have you done. However, if we put that aside, if we look closer at the jurisprudence that is coming out of the courts, the mechanisms, we do see that women are contributing. I'll mention just 2 without going into details. One is Judge Navi Pillay from South Africa, who sat on the International Tribunal for Rwanda and also served briefly on the ICC before going to the Human Rights Commission. And she, amongst the other judges who heard the Akayesu case regarding Rwanda and the rape, which really set international law saying that rape can be considered an act of genocide. Now, in as much as she is often seen as the judge who read the lead judgment and her contribution throughout the trial, I also think it's worth giving credit to the 2 other male judges who were on it, so that we are not seeing this as a fight between men and women who can do better. It's about collegiality on the court, on the bench, which is really what we want to promote, how male and female judges are working together. Lastly, Judge Julia Sebutinde, who I just read, also served on the Special Court of Sierra Leone. And in a dissenting opinion, which is important, it wasn't part of the majority, but a dissenting opinion, she made a clear distinction between the understanding of a forced marriage and marriage in a time of war, in order to let people understand that it constitutes violations under human rights, and therefore should not be thrown out in their case as it was done. So these are just 2 examples to show that women do contribute to the jurisprudence, but the question shouldn't be what have they done, what are they doing? It's about what is the bench doing.
Excellent, yes. And I think it is really interesting to see this emerging trend between our 2 panelists so far on the really important, the fact that this question is really one of the entire ecosystem. You know, it's not just the judges, it's also the laws, it's also who has access to the courts as well and what kind of cases are coming. So Commissioner Macaulay, please close us out on this question.
Thank you very much. I'll be as quick as I can. As I'm sure you know that, like the African court, states have to accept the jurisdiction of the court after they have ratified the Inter-American Convention of Human Rights. And all the Latin states have accepted the jurisdiction. And presently, only one Caribbean state has. Canada and the US, of course, have not. And so therefore, the cases cannot go to the court if you haven't accepted the jurisdiction of the court. And the commission is the primary organ for the promotion and advancement and monitoring of human rights in the region. Clearly not the court. But since it took the court up to 2006, when they made the decision in the Castro versus Peru case on rape, to decide on the issue of rape as a human rights issue, which they then went further to say that even a single rape can be an act of terrorism and terror. And there was a woman on the bench then. And when you look at the history before, it is clear that if there wasn't a woman at that time, that case might have gone to the side as other previous decisions had done, without focusing on the issue of rape being a violation of the woman's human rights and things. And thereafter, women were in the court until 2012, December 2012, which was when I left. And we did, during that period, a myriad amount of cases which dealt with, for instance, there's the well-known case of the cotton field case, the case of Gonzalez and others versus Mexico, which is the Juarez situation of so many women who were killed, disappeared and killed in that region. And some of the women dealt with in that case. And where we made very wide but effective rehabilitative directions for the state to execute in order to ensure that the stereotyping mindset of the police, the judges, the community, the citizenry also change vis-a-vis women and their rights to protection. Then we also did a case on sexual orientation. In fact, the petitioner was a judge. And the decision, that is Atala Rifo and the girls and her daughters versus Chile. And in that case, then the domestic judges were appalling, the statements they made. And in fact, I remember one statement I made to the state of Chile. They are in effect saying that the children could become lesbians by osmosis because the mother decided that her partner should come and live with them. Then the agreement that she had with the father went overboard and he fought through the court, and including statements by the Chief Justice, in relation to which I wrote a separate opinion because my brethren did not agree that we should critique his statements. And I'm afraid I felt very strongly about it because as the Chief Justice of the court, he ought to have known better and acted better. So I wrote my separate judgment in that. And then the cases from Brazil, which related to employees who were injured and some died in the fire in a factory. And there was the in vitro fertilization case, the majority of which applicants were female. And then there is the forced and illegal sterilizations of women, which we did as well. And I think that in some of these cases, one needed the nuance of women to really bring out what ought to come out in the jurisprudence of those decisions. And it did so. So I think women's presence has been proved over and over several times. And I think really there should be no argument on the matter.
Thank you very much. And I think that that's a very important point as well, is, you know, where cases affect people, and some of those people are women and they are affected differently because of that. It is so important to have that perspective and understanding of how that plays out in real life. And I think maybe to start our oh, yes, go ahead.
There's also the import of being a common law lawyer in the midst of civil law colleagues, because I've always been the only common law lawyer, and arguing from the basis of common law. And we arrive at what is a hybrid, a mix of the two systems of law. But we have basic standards in both that appear in both. But it was good to be there to also push common law standards.
I love that. The inner law student in me that always exists is so intrigued. But so to open our broader Q&A segment, and again, please, anyone in the audience, if you have a question, feel free to share that. But I will take the prerogative to start with a question that I think has been touched on by everyone already, a little bit at least, which is the importance of men in contributing to gender equitable jurisprudence and progress. And so I'm curious about, and I would direct this question at anyone who wants to answer, but perhaps I'll start with Professor Dawuni, if you have thoughts on this. In your view, has the absence of men in bodies focused on gender and women's rights affected progress towards gender equity? And if so, how? For example, something I was thinking about was we might consider that only one man sits currently on the CEDAW committee, or the fact that, again, at the UN level, there has never been a male special rapporteur on trafficking in persons, nor has there been a male member of the working group on discrimination against women in law and in practice, even though men, of course, occupy key roles in legal and other institutions that have to change their approach to gender in order to make progress in that arena. So, and as a follow-up question on that, perhaps, what role do you see for increased allied male support or leadership on these issues?
Yeah, thank you. So I am unapologetically a feminist, womanist, humanist, all of that. And I always say that I come from I view my feminism, and that's why I use the word womanism sometimes, which speaks more to the lived experiences and practicalities and historical positioning of African women and Black women generally, or women of color, Black women generally in the African diaspora. So we're talking about whether in the continent of Africa or located outside the continent of Africa. So for example, largely in the Caribbean region or in the United States or Europe. That positionality speaks from the historical positioning within our African communities of a sense of communality, a sense of complementary gender roles that most people don't know this because of the history or colonization, which really disrupted gender roles across the continent of Africa and exported it to the African diaspora. So what we're seeing now are some of the issues that we may say patriarchy within the Black communities or African communities is really a reinvention of that. That's not to say that African systems did not have levels of patriarchy, but those patriarchal systems were totally overhauled and probably taken to a higher level as a result of colonization. So let me not move into too much of the history, but anyone who wants to read it can read more about how African systems were gender complementary roles. Women had their roles to play, men had their roles to play, but there was a mutual understanding and sometimes intersecting of these roles. So within those spaces, you could find that women were political leaders as chiefs making decisions with men in the courthouses. Within the African system, Ghanaian system, women were the chief makers. So you talk about the top position, who chooses who the leader, the male leader is going to be. Women fought in wars against colonial governments and against their old territories. So with all of this, I'm coming to the point that I believe personally in what I call gender solidarity, based on African systems of what we call Ubuntu. We work together and we live together and we prosper together. So bringing my African epistemology into the space that I work within the legal arena, I move on to say I'm very intentional about involving men. I'm very intentional about diversity, not saying that, well, it should be an all-women's panel. Well, I guess we might be faulted for that on this one, but that it also involves men, but men who understand or who are willing to learn and who are intentional about their acts. So for example, within the Institute for African Women in Law, we're just about to launch a campaign, which we call the Gender Solidarity Campaign or the Male Allies. And these are men who we have assessed and believe they have a track record of being sensitive to gender issues, being inclusive, and who are committed to promoting women's gender issues. So it's important to have male. I have also done a lot of interviews of judges, international courts, into domestic courts, and I have spoken to amazing men who are really committed, who believe in that. And that we can also see in some of the jurisprudence that they've produced. So all of that to say that we do need to have men as allies. And I have a quote, which I am going to share out there, that if we want to go with the hypothesis, I'm speaking as an academic, that men are the cause of the problem of gender inequality, shouldn't they be part of the solution? Because if they are not, we're just giving ourselves as women too much work. The extra burden, the extra care work that we're always finding ourselves doing. So let's be intentional about bringing in men who are sensitive to gender issues. And these men must be willing to hear what the experiences are because they don't know it. And most importantly, the women or feminists must also be willing to embrace men who are sensitive to these issues so we can work together for the common good of humankind. So very quickly to end up, that I believe that these organizations, whether the Human Rights Council, any of these mechanisms do have to have a balance. Because in as much as women can do all the work, and we don't want set out to be all women, we also know that there's something called institutional cultures, which has a hierarchy where we believe that these positions are male. So when we're talking about security issues, men, there is some reasoning behind that. And that also has to be changed. Those cultures have to be changed. So women can serve on those powerful security panels and powerful security bodies, just as men can do. And also that men must be part of CEDAW, must be part of the mechanisms for the rights of children, because those are issues that don't affect only women. They do have an import on all of society.
I think that answers it all. I agree. I think I can't add anything to that. I agree with it wholeheartedly. I think we're shared humanity and we should share responsibilities, obligations, duties, and power. Share. I believe in it fervently. And this is what I fight for. We need parity.
Well,
Yeah.
I also like the African inclusive model, and I also have to say that without the help of two really inclusive men, namely Tom Bergenthal and Karl Döring in Germany, I doubt whether I would be there where I stand. And this Karl Döring especially, he had really to fight for me. He was ridiculized at the university for making me a law professor. Yeah, it was, but he was a very strong person, so he could do it. And and as you said, a balanced society and seeing the full picture, of course, includes men. Yeah. And we have some nice female networks now, for example, women in international tax law or women in competition law, and they are great, those women networks. But in our events, we usually put a man on the panel, and it's good so.
Absolutely. And I also, I think, as I think more about this question and this discussion, I am also reminded, I think, of what you were mentioning at the beginning, Commissioner Macaulay, about the effect of domestic pushback and domestic cultures on women being able to rise into regional mechanisms as well. And I think you mentioned actually working on the states and making inroads, perhaps diplomatically, perhaps otherwise. And I was curious if you would elaborate on that a bit. I think that sounds like a very interesting area of work, and unfortunately, an extra burden.
Yes, indeed. Well, as you know, it is necessary for us to do push for parity in all decision-making levels and of any state. It's part of our mandate, and we have to do it because of our regional characteristics in the Americas. Because we're particularly honest about the fact that South America and Latin American countries are the most machismo, apart from maybe Spain and Portugal and some other states on the other side of the world. But it is very, very machismo, filled with stereotypes of women which go way back into archaic times. And so therefore we have to use whatever tools we can imagine to assist the states and convert thinking to the point of view of feminist entitlement, women's entitlement. And we use diplomatic chats whenever we meet at the OAS with state representatives, and especially after the meeting, we have a convivial get-together with wine and stuff. It makes it easier to talk to ambassadors and representatives of states and explain in why certain things had to go in a certain way, and end up by getting, even though it's in an informal setting, you get them to respond, and it's obvious that they then understand what you are explaining and what you want them to put into their DNA, which they would take back to their state officials, because then it is so inbred, and that the domestic decisions would be made based on these principles. And it has worked, because I've used it personally myself in relation to our convention on the against all racism, racial discrimination, and related forms of intolerance, to get states to sign on to it. and to get ratifications. Since it came into, it was put out for what was ready and adopted by the OAS in 2017. And to date, we've had 6 ratifications. Now, this is an area which is steeped in racial discrimination as well. North, South, all over. And so for them to ratify, 6 to date to have ratified it, and 12 to have signed and working towards ratification, meant I used to buttonhole every ambassador I would see and talk to them about it and why it is necessary and why it is necessary for their particular state to do so. And it does work, and it does have results. And we work together as all the commissioners are rapporteurs of something or the other, and we work intersectionally as best as we can. And so, and we travel around the area quite a bit. We actually have our periods of sessions within states. So when we're there, we're right at the seat of power and use that time effectively as well to work. And we work closely with civil societies of the region who assist us. They are fantastically committed and active in the pursuit of certain principles which assist our mandates, including this one of parity of women in judicial and legal tribunals. And so we tend to see results, not as much as I would like, because I keep on thinking my time is getting shorter and shorter. But we do see results because we have this partnership with them. And we have this, I should say, the atmosphere in the OAS where these people are approachable. And when we have meetings in their cities, in their countries, we do not only stay in the cities, but we meet first with the head of state and the executives and speak directly with them and openly. And then we go out to various rural country towns and so on and speak with the people, and we speak to them directly and all openly and publicly. So we find this system very effective, and we get the people to understand that they have the power to assist us and work with us. And so therefore we have a good partnership, which is what we have to do, make partnerships as we go along. Yeah. I think I'll leave it there.
Absolutely. I love what you're highlighting as well about the institutional aspects, like the period sessions, the moving period sessions, which allow for certain types of diplomacy and relationship building. And I think that also reminds me a little bit, Advocate General Kokot, of what you mentioned at the beginning about the institutional foundations that allow for progress in terms of gender equity, even where representation has not, or even where gender parity has not been achieved yet. And so I want to ask you then, in terms of, to elaborate perhaps a little bit more on that point, because we know the Court of Justice of the EU has certainly advanced gender equality for Europeans, even though less than 1/5 of the judges and advocates general are women. And so what lessons can be learned regarding the inclusion of women, and what can be shared perhaps with other regional bodies?
Yes, I said there are not many women judges at the judiciary, at the member level, but we have really highly qualified legal secretaries, and they are, I think, almost 50% female meanwhile. And those legal secretaries sometimes end up as judges, as members of the court, as, for example, our current president, Koen Leenaerts. So I'm very happy that gender equity has really been reached at the level of the legal secretaries. Why? As said, it's really difficult and a big issue in Western Europe to combine career and motherhood, because a family does not function, not such sense as possibly in Africa or other countries. Unfortunately, very individualized society. It's the business of the mother, the child, and domestic help is not affordable, because that would discriminate the mothers, which is I doubt whether women judges would support such system, but it's still there. And this is not so at the Court of Justice. There is very generous maternity leave, 5 months paid maternity leave. I think maternity leave must not be too long, otherwise you forget everything, but 5 months nicely paid. And, which is important, you also get the employer, or me as a judge, I get a replacement for this woman who takes maternity leave, and qualified replacement. It's paid, yeah. So it's not a really problem, and I think that helped a lot. And then I have to talk about another subject, which is unfortunate. I think besides those framework conditions, there is also an important psychological component in the empowerment of women to engage in high-profile judicial careers and other careers. And this contributes to auto-limitation of women. In former times, women always wanted to be teachers at school because they could combine that with motherhood. And now the first instance judge is a new teacher. The young legal students, often female, want to become a low instance judge and then be there and take lots of maternity leave in Germany. And that's a traditional role model. And next Monday, another book will be published by some journalist of a leading German journal, Frankfurter Allgemeine, what it means to want a child. And she makes a real big issue of possibly becoming mother, maybe or maybe not, because these women are afraid to becoming uncool, to end up as uncool mothers. I really found it crazy. And so I think one has to encourage young women and show that it's just possible. And instead of writing such books, you better work and combine it, or just showing that it can be done. As one American student told me when I was at the American Society of International Law, there was one famous public international lawyer who had 3 children, and this other student said to me, this shows that it can be done. We have to show that it can be done and serve as role models. Yeah. Thank you.
Thank you. Yes, and I think turning to the African continent, perhaps I'll ask the same question of you, Professor Dawuni. Are there good practices that African experts recommend that states adopt in nominating, electing, or appointing candidates that can ensure gender balance and parity on that continent, or perhaps at the UN level, since we haven't really touched on the UN level very much?
So thank you. So I think maybe I'll take you as to the UN level a bit. So October or November last year, the Institute for African Women in Law co-hosted a high-level meeting with the special rapporteur for the UN Human Rights Committee, because the Human Rights Committee had charged the advisory committee to produce a report on the underrepresentation of women in UN treaty bodies. So the Institute put together a panel of experts across the continent who were judges, diplomats, civil society organizers, academics, to really talk about these issues within the UN system from the African perspective. And the committee wanted to hear from regional bodies. So they had convened a meeting in the Latin America region. They had done some meetings in Asia. And so we kind of hosted the Africa group. And most of the findings that came out, I'm happy to say the report was approved by the Human Rights Council, and it's going to be coming out next month. And I think final approval in July. And so the recommendations really were not far-fetched from what the hearing group had heard in Latin America and Asia, which was that when it comes to international bodies, whether in courts, tribunals, or human rights mechanisms within regional bodies or within the UN, I think Commissioner Macaulay said it really starts with the states, because international relations say states are the primary actors. So the states will have to do the nomination. So if states are not using transparent nomination processes, if the states are using male-dominated networks to get to candidates, if states are relying on men who often hold the power, who have the decision-making, who would often also tend to other men to nominate, that means that it already limits the pool. Now, if the states or particular states do not have gender parity rules on how we nominate, if they don't advertise the position openly and broadly and on time, that means that it further limits the opportunities for women. Now, apart from the states, there was also discussion about the role of civil society organizations. I think we've talked about that already, whether these organizations are human rights organizations generally, or if they are specifically women's rights organizations or other professional organizations like bar associations and judges organizations. They also have a role to play, but they can play that role within the state if the state allows civil society to flourish and to have a voice and a seat at the table. So in instances where we've seen civil society organizations play an important role, we've seen some positive outcomes in terms of recommending names of qualified candidates. And lastly, beyond the civil society, I also want to mention one thing that came out from that meeting. It's also about the individual. And I know we don't want to put the obligation on women to say that you have to be qualified and you have to know, yourself, because we've talked about it. It places an undue burden on women. It places that extra question we ask, are they qualified? And I don't like to hear the word we should look for qualified women. With men, they say we should look for men candidates, but with women, we say qualified, or worse still, we say well qualified. So that already presupposes they are not there. But research has shown that they are qualified women. Within the African context, we've had over 27 women who have been chief justices of courts across the continent. Within the International Criminal Court, the African region has had the highest number of women represented in the ICC. Europe, on the other hand, has the lowest number of women. So that means that we do have these women who have a long record in all these spaces, and they can fill those positions. So what can be done? What did we learn from that group? That states have a role to play, civil society organizations broadly have a role to play, and individuals also have a role to play. The women candidates, and I think that talks maybe to what's been discussed already, that we also need to put mechanisms of training the next generation, the pipeline. So at the Institute for African Women in Law, we're doing that. We're creating these pipelines where we are mentoring women who would also aspire to get into these leadership positions in international courts or tribunals, because sometimes as law students or when they come out of law school and they're practicing, they don't even have an understanding of what these mechanisms are. I'm always reaching out to judges and saying, you are going to be the next candidate or for this position, or you're going to be the next person to be promoted. And like, no, it's not me. I'm like, yeah, it's you. And so we also have to do the encouragement. Individuals will have to know what it is. And once we demystify the process, we will have no problem getting women into these positions. So I'll end on that note to say that that council, the Human Rights Council, has benefited from those recommendations. My colleague, Professor Elizabeth Salmon at the University of Peru led that group. And so I'll be happy to share the report when it comes out to help inform the UN Human Rights Commission and other organs about how to increase women in these positions within the UN system.
That is really exciting all to hear, and please do share that report. I personally would love to see it. I think we all would. And I think I could continue this conversation forever. This has been so wonderful, but unfortunately we are out of time. But I do think that that is the perfect note to end on, for for WFM-IGP as well, the role of civil society. Can feel good about that. And truly, thank you all for being here today. This has been a really inspirational and fascinating discussion. I think.
Thank you very much for combining us.
Yes, no, applause really loses its effect in the virtual world, but I want to applaud.
And we all enjoyed it, and we really appreciate and thank you for having us.
Mhm.
Yes,
We can continue conversing, and there's no reason why we should not in a few months have another.
Yes, and in real life,
Yeah.
Indeed.
Jamaica or Washington,
Yes.
Yes.
Costa Rica, support.
Yeah, we are happy to host anytime. And also, I think what this shows us is the importance of working across regions and across spaces. And it's important for us to recognize that all women's voices do matter in these discussions, and that there's a lot of learning that has to be done. Within the African context, there's been some positive outcomes within the European context, within the Caribbean region and other spaces. And we have to be open to hearing the voices of all women and learning from each other. And that I think will be important for moving the agenda forward.
Absolutely. Yes.
100%. And thank you so much, Professor Dawuni, and to the and to your organization for co-sponsoring this as well. This has been really a privilege.
Yeah. And transparency of the choice process is important. Yes. Thank you, thank you, thank you. I enjoyed this. Thanks. It's good to be with you all.
Thank you. Thank you. Same here.
Thank you all so much. Take care, and hopefully we'll reprise the conversation in the future. Not too distant.
Thank you. Bye.
Bye.
Bye.